Good morning. Welcome to our first live session and our third day. It's been a successful oral argument. We're glad to see you all here. Trust that our arrangements will keep you safe. Brian, let's call the first case.
Lorino versus Workers' Compensation Appeal Board in the Commonwealth of Pennsylvania. Representing Mr. Lorino is Mr. George Beatty III. Representing the Commonwealth is Ms. Deborah Beck.
Mr. Beatty, feel free, but I'm going to explain what the case is, and you listen, and if I get it wrong, then you re-educate us, and if not, it helps the people behind you we trust. In this appeal, appellant, a workers' compensation claimant, seeks review of the Commonwealth Court's interpretation of Section 440 of the Workers' Compensation Act to allow for the payment of a claimant's attorney's fee only in circumstances where the employer's contest of the benefit is unreasonable. Appellant argues the relevant language of the statute indicates that attorney's fees may be excluded when there's a reasonable basis from the employer's contest. Appellant asks this court to reverse the Commonwealth Court's long-standing interpretation of the statute as contrary to the legislature's plain language. And if that's right, go ahead and proceed. We, as I think our instructions show, are a hot court. We understand your case. You don't have to explain the facts to us. Just tell us succinctly why you're right.
Thank you, Mr. Chief Justice. May it please the court, my name is George Beatty, and I represent the claimant appellant in this case, Vincent Lorino, a laborer for the Pennsylvania Department of Transportation, driving heavy equipment, who was injured on the job. But he also was not injured so severely that he was unable to work. He was injured so he needed injections in his spine every few months, but he wanted to keep working. So he kept working, and he got his injections. And then the insurance company decided, we're going to cut him off, and they filed a termination petition against him. A termination petition can only help the insurance company. It can't do anything good for an employee, an injured worker. Mr. Lorino engaged my representation, and we contested the termination petition, and we were successful. And the compensation judge said, no, he's not fully recovered. We're going to allow him to continue to get his injections and his medical treatment. Anyway, as a result of that, the workers' comp judge then said, sorry, we cannot award any fees here because the insurance company presented a doctor who had a medical license and who uttered the magic words that he is fully recovered. And with simply that, they said there is a reasonable contest, and therefore they're not going to award any counsel fees. And that goes directly contrary to the plain words of the statute written by the General Assembly. So this case presents an opportunity for this honorable court to correct a basic and fundamental misinterpretation of the Workers' Compensation Act. It presents an opportunity for this court to correctly apply the Statutory Construction Act so that the words of the statute are given their usual and customary meaning. And finally, this case presents an opportunity for this court, as the highest level of our judiciary in Pennsylvania, to reaffirm the separation of powers doctrine and declare that our courts are here to interpret statutes, not to rewrite them. I also want to point out that this case only impacts a narrow class of injured workers, those injured workers who are not receiving weekly wage benefits. It is this class of injured workers who are most vulnerable. Those are the people who need medical treatment for their work injury, but they can't walk into a lawyer's office and say, here, I'll sign a 20% contingent fee agreement, because there are no benefits from which to draw a lawyer's fee. So they can't provide a contingent fee because they're not getting those kinds of benefits. The analysis in this case is very straightforward. The Statutory Construction Act does apply, but right up front, I want the court to understand our position clearly that the Statutory Construction Act is employed to interpret statutes when the language of the statute itself is unclear for some reason. In this case, it's not unclear. It says, for a prevailing claimant, that's another thing I wanted to clarify, only claimants that win are entitled to an award of fees. If they lose, they don't get paid. The lawyer doesn't get paid either. But if they win, the statute says the prevailing claimant shall be entitled to an award of counsel fees. And then it says, provided, however, if there is a reasonable contest, the judge may exclude fees. The Commonwealth Court's interpretation clearly, without question, substituted the phrase may be excluded with shall be excluded. The only, yes, Your Honor.
If we decide may means may and shall means shall, and therefore you're correct, do you want us to remand the case to the referee, to the WCJ, I'm sorry,
Yes.
to reconsider counsel fees?
Yes, Your Honor.
And what criteria do you envision the WCJ using?
I think the criteria would be set by this honorable court. This court hopefully will say, look, the statute is clear. They shall be awarded, but they may be excluded. They not shall be excluded in every case. So in this case, where we have a medical-only claimant, a person who's injured but is continuing to work and therefore cannot provide a regular contingent fee to a lawyer, in those kinds of cases, this court should declare to the workers' compensation system, to all the WCJs and to the Workers' Comp Appeal Board, and importantly to Commonwealth Court, that courts interpret statutes. They don't rewrite them. And the majority opinion, I'm sorry. Yes.
No, I'm sorry. Do you want to finish your comment?
Yes, and the opinion, Judge Brobson of the Commonwealth Court wrote this opinion, and I was frankly a little bit surprised at how blunt and direct it was. The words of his opinions, they were direct. He said, he changed the word may to shall, and he said, and I quote, despite the General Assembly's use of the word may, this court has always interpreted Section 440, unquote, in this way. So he laid it right out there. I mean, I'll give him credit for that. He said, we rewrote the law. Despite the General Assembly's language, we have done this. Well, you're not allowed to do that, respectfully.
What occurred in preparing for the argument, as we all do, as you know, what occurred to me is that we may be fighting a little bit, although I understand why you're here, more about form than substance, because assume that we go back and the criteria for the award of counsel fees is the reasonability of the contest. Now, rather than being if it's reasonable, you lose, it'll be perhaps some sort of sliding scale of reasonability, but to the extent that the referee uses reasonability, the WCJ uses reasonability, unreasonability as a criteria, as one of the criteria, and says, in my discretion, I don't award fees, notwithstanding that the fact that I have the opportunity under statute to do so, you're going to be hard put to find abuse of discretion, and this whole exercise will be interesting but of little value.
I respectfully disagree, Mr. Chief Justice, and I'll explain why. The way you describe it, you would have to go back and decide what is reasonable. We're not asking this court to rewrite the case law on the issue of reasonable contest. That's out there. Unfortunately, for some claimants, it means that they can hire a doctor, like Dr. Barr in this case, who comes in and says, I looked at 54 pieces of medical records. I looked at gastroenterology and dermatology for 14 years or whatever it was. And then he says he never saw the records of the injections into my client's spine. He didn't know what the medication was. But as weak as that opinion is, he uttered the magic words for $3,500 he was paid, and he said, in my opinion, within a reasonable degree of medical certainty, Mr. Lorino is fully recovered. So boom, right there, they have a reasonable contest. So I'm not asking this court to rework what reasonable contest means. You don't have to touch that. All we're asking the court to do is say, in certain classes of cases, even if there is a reasonable contest, even if they pay a doctor like Dr. Barr to say the magic words, in a case where here's a claimant with no weekly benefits, he only has medical benefits, he is more vulnerable than any other kind of claimant because he doesn't have that ability to pay a contingent fee. In those kinds of cases, even if there is a reasonable contest and the magic words, this court can declare in those kinds of cases, fees may be awarded, okay? And that's what the statute says. The statute says may, okay, not shall. So the only way to interpret this statute in the way the
Give you therefore the ability through cross-examination and through your experts to show that some criteria has been met, and therefore you can have counsel fees. But it's still going to be in the discretion of the WCJ.
It would, of course, and that's another issue. The WCJ, by its very nature, the system, entrusts the WCJ with discretion. Discretion to award benefits, discretion to find disability or not, discretion to award counsel fees, discretion to award penalties, discretion to award whatever other relief the Workers' Compensation Act can afford. So providing giving discretion to the WCJ to award counsel fees in cases where there is a reasonable contest is not a departure from standard practice. This court and other courts have trusted, we all trust the judges to do the right thing, and we entrust them with the discretion to do the right thing. That's what we're asking for in this case.
While I have your attention, does 442 enter into this case at all?
It only would enter into this case if a claimant were to lose. So if the claimant, if we fought this case, and I have a fee agreement with my client for an hourly fee, and we fight this case, and we lose, and the judge says, I believe, Dr. Barr, you're terminated from benefits, you lose. Then my fee agreement would be interpreted under 442, which gives the WCJ discretion. You know, he's not bound or she's not bound by whatever that agreement says. The WCJ under 442 says, look, I know your fee agreement says this, but I'm the judge and you're going to get this much. And that's the way the system's supposed to work. So it's entirely consistent, 440 and 442. So I just want, you know, this case is governed.
Counsel, can I
Yes?
follow up on that? I don't understand 442. Because what it says is, I looked at this as the provision in the Act that sets the standards for agreements between claimants and their counsel for attorney's fees, period. It has nothing to do with whether they win or lose. I mean, it starts out by saying, in cases where efforts of claimant's counsel produce a result favorable to the claimant. That would mean, in this situation, if you had an agreement with your client, which I'm sure you do, I know you do in this case,
Yes.
that they pay you $150 an hour or $500 an hour, whatever it is, that fee could be approved by the workers' compensation judge. It doesn't have anything to do with win or lose. You just don't want to collect from your client.
That's correct. 442 applies exactly as Your Honor just
Okay, so it
described.
had nothing to do with winning or losing. You say that in your brief also. This only comes into play when a claimant loses. That's just not true.
Well, it's not true globally, but in the context of this case, and this case being when a claim, what we're asking this court to do is to say, in situations involving a medical-only claimant, where the individual, the injured worker, does not have weekly benefits, where he could go to a lawyer and say, take 20% of my weekly benefits. I'm getting $1,000 a week, take 200 of it a week, and represent me and save my benefits. That happens all the time. This case is different. This case involves an injured worker who said, I don't want to go out of work. I don't want to collect benefits for weekly wages. I want to keep working, but in order to keep working, I need to get this injection of medication into my spine. So he did do that. So in those situations, he can't get a contingent fee.
But that doesn't have anything to do with winning or losing.
That doesn't, but the way this court will decide this case.
No, I mean, the Chief's question was, what does 442 say?
442 regulates the ability of the workers' compensation judge to award or disallow or modify whatever. Win or lose. But what I'm saying is, in the context of this case, you're absolutely correct, Madam Justice. It's in this context, however, it involves the discretion of the workers' compensation judge to approve or disapprove, whether it's the hourly rate, the number of hours. It's completely within the discretion of the judge, as it should be, as the legislature intended. But the legislature did not intend, and the language is very clear. So I hope I've addressed your... Okay, so this case is governed by the Statutory Construction Act and the Separation of Powers Doctrine. The purpose of this, and it's funny when you actually dig into it and research it, it's fascinating. The purpose of the Statutory Construction Act is indeed to underscore the Separation of Powers Doctrine. It draws clear and unmistakable lines. The General Assembly writes statutes. The courts interpret statutes. The courts don't write or rewrite statutes. And here we have a statute which is a humanitarian and remedial piece of legislation that was initially enacted back in 1915. It was designed to benefit injured workers, to put them in a situation where they wouldn't go bankrupt and lose their homes and their families' support. It's humanitarian and remedial, and I cited many cases in my brief.
And we only need to resort to that if we find ambiguity, right?
That's correct, Your Honor. Yes, exactly. I couldn't have said it better myself. I'm just throwing the kitchen sink at things here, Your Honor. So you don't even have to go that far. That's correct. I mean, I would like... plain language, and that's what we've got here. We've got plain language, and, but here, again, he said, despite the language of the General Assembly, I was sort of like, as much as I was like taken aback by it, I was a little bit happy because I thought, well, gee, if I get to come up here, it's going to be helpful to say, he said, despite the words of the General Assembly. You can't do that, respectfully. The courts are not supposed to do that. So this is a bold and direct usurpation, is that a word, or repudiation of the legislature's role in government. And it just basically, okay. Okay, Your Honor. I'll just sum up, if I may, Your Honor. Okay. I just want to put as an aside, it was fascinating researching this thing. In 1852, that case Dowd versus Truby, I don't even know if this building was here at that point, but the Supreme Court back in those days said, may does not mean shall. They said that 169 years ago, and I thought, imagine in the year 2190, that's 169 years from now, somebody will be looking at you justices and say, this is what those folks said way back in 2021. So in closing, I would urge this court to please respect the separation of powers doctrine. Please comply with the Statutory Construction Act. Please do not rewrite the statute, because if you affirm here, you are also rewriting that statute. And please reverse the decision of the Commonwealth Court. Thank you very much.
Ms. Beck?
Good morning.
Good morning.
May it please the court, I am Deborah Beck, Esquire, on behalf of the appellee in this case. The Commonwealth Court, in rendering its opinion, did not violate the separation of powers doctrine because the Commonwealth Court never replaced may with shall in Section 440 of the Workers' Compensation Act. Instead, in coming to its conclusion that employers should not pay Section 440 attorney's fees directly to claimants' counsel, the Commonwealth Court comprehensively analyzed over 30 years of jurisprudence of not only the Commonwealth Court, but also of this honorable court, which has consistently interpreted Section 440 pertaining to the awards of attorney's fees. This jurisprudence focused on whether a reasonable contest was presented by the employer, as this is where the focus should be, in order to protect claimants from unscrupulous employers and/or insurance carriers.
Why isn't that, if I may, counsel, why isn't that an adjustment that the General Assembly should make if it wants, rather than us? I mean, it would be simple for the legislature to, they could do it right now, I guess, and send it to the governor to just replace may with shall. I mean, in the same section, they use the word shall, so they know how to use the word shall. Instead, they've used the word may. So why do you need to get us to convert may to shall rather than asking the General Assembly, if that's what they so clearly want?
Well, again, I think, you are right, the General Assembly could rewrite Section 440. They did actually rewrite Section 440 in 1993 when they passed Act 44, and they actually took out the second paragraph of Section 440 in the previous section. That section paragraph gave claimants what Mr. Beatty is here today arguing for. The fact that in an employer-driven petition, if the employer did not win, attorney's fees should be paid to the claimant, When the General Assembly looked at it in 1993 and rewrote the act, they took out that second paragraph and moved the employer-driven petitions up into the first paragraph. They did not look at the may versus shall. I don't know why they didn't. This court has indicated that the legislative intent under Section 440 is the reasonableness of contest and to protect injured workers from an employer that could have an unreasonable contest or a meritless claim.
But you don't disagree with the proposition that we glean their intent from the words they actually used. I mean, there are how many legislators there are, they might have all kinds of intentions which could change between breakfast and lunch, but the actual word that they put into law is what we have to go by, isn't it?
It is, but there have been cases that have indicated that in the interest of justice, may can mean shall. So there is that ambiguity. And this honorable court has looked at the intent of the legislative branch in deciding cases regarding unreasonable contest. This court.
I'm reasonably confident that if we ask the members of the General Assembly if they want us to disregard the words and do what we think is in the interest of justice, they wouldn't be too pleased. Is that what you want us to do, just sort of do what we think is just regardless of the words?
I think you could stand behind your prior jurisprudence, and no one was, the focus should be on reasonableness of contest.
Counsel, with regard to our jurisprudence, in A.S. Scott from 2016, the majority of this court and I authored the opinion which indicates that may can be interpreted as a mandatory only when the ends of justice or constitutional requirements so require. Share with me, what's the constitutional requirement or the end of justice in this particular case? Because I'm following your lead. I want to follow our jurisprudence. You win if you show us that this is an end of justice or constitutional requirement so dictates.
Well, it is an interest of justice. In this case, the claimant, Mr. Lorino, was actually working and collecting his full salary. He had the ability to pay his attorney. He actually entered into a contract with his attorney as far as the contingent fee agreement to pay his counsel $400 an hour. What Mr. Beatty is asking this court to do is to create almost a superclass of those claimants who are continuing to work, but are getting their medical benefits paid for by the self-insured or the employer's insurance carrier.
So what you're saying is, should he not get the injection which permits him to work, that he'll be ill and you'll have to pay both income and medical? That's your solution, correct? If he can work full-time, but the caveat is because he's getting these spinal injections or the cortisone injection, your position is let him pay for them. If he doesn't have that income or cannot afford, he's now disabled, but that pain that was originally occurred at the job. So I'm somewhat confused at your circular argument.
Well, we didn't deny the payment of the injections. The Commonwealth did pay for their injections. The problem is that in order to not continue to pay for medical benefits for the lifetime of an injured worker, the Commonwealth has to file a termination petition to stop those benefits. So the Commonwealth in this case accepted a strained sprain and a strain to the hip. Strains and sprains typically last 4 to 6 weeks, maybe longer. After 7 months, the Commonwealth obtained an opinion from their medical expert and filed their petition to terminate compensation benefits. They're allowed to do that within the Workers' Compensation Act.
And you lost. And the statute says under those circumstances, the referee may award fees. What's wrong with that? It's a humanitarian statute. The amount of money that he doesn't get any money. All he gets is the medical benefits, and he wins the battle and loses the war if he has to pay the cost of counsel fees when you attack under this circumstance. And I'm not saying you didn't have a right to do it, but I am saying that the statute says if you lose, you may have to pay fees. And I use the word may there unintentionally, but that's what the statute says. Let me ask you just really quickly, because I think we understand the case. There is a precept of statutory construction that if the highest court in the state, which is us, of course, has ruled directly on statutory language, the legislature has then, I think it says, has then looked at that statute and not changed the language that they accept our interpretation. And I looked at that in this case, but I did not find a case where we've answered this question. I found the Mason case, and I think the Farquhar case, in which we ruled on different questions, on burden of proof, on whether you need reasonable basis to get fees. But I saw nothing where we ever got into the shall or may. Did I miss a case?
No, this case is one of first impression, but the shall versus may distinction has been raised in other cases, such as Mason, which was ruled upon under the prior section 440. This court in Ramick in 2001. Well, it was a different question in front of you. This court did have to look at the legislative intent of the statute, and this court in Ramick also focused on the reasonableness of contest, and in fact indicated that it's presumed that the employer has an unreasonable contest until such time that they present evidence so the judge can find a reasonable contest. So whenever an employer walks in the court, we pretty much have that presumption that our contest is going to be unreasonable until such time a judge looks at our evidence and finds that it is reasonable. And it's the employer's position that it still should remain the reasonableness of contest that is the focus in this case, not the shall versus may distinction. And therefore, we ask that you affirm the Commonwealth Court.
May I ask a question? Counsel, I had a question regarding your construction of Judge Brobson's opinion from the Commonwealth Court. On page 10, Judge Brobson says, in line with this legislative intent and despite the General Assembly's use of the word may, which is the portion that your opposing counsel referred to, despite the General Assembly's use of the word may, this court, meaning the Commonwealth Court where he sits, has always interpreted Section 440 to mean that attorney's fees shall be awarded unless a reasonable basis for employees' contest has been established or otherwise expressed. The award of attorney's fees is the rule and their exclusion is the exception to be applied in cases where the record establishes that the employer's contest is reasonably based. Now, that seems to be the center of argument by both of you. My question is, in that opinion, Judge Brobson goes on to cite a number of Commonwealth Court cases, and I wondered, is there a decision from this court that you believe sheds any light on that?
Mrs. Justice, Madam Justice, yes, Ramick is Ramick versus WCAB, Shaz, S-C-H-A, ATZ Electric. Actually, Justice Brobson, Judge Brobson, sorry, actually quoted this honorable court's holding in Ramick when he said unless. In Ramick, this honorable court noted that the clear and unambiguous language of Section 440 puts all employers on notice that they will be responsible for a claimant's legal fees if they engage in an unreasonable contest, and an employer always has an opportunity to defend against an award of unreasonable contest.
You're focused on the latter part of what I quoted where Judge Brobson talks about the reasonableness. I was focused on the earlier part, which was relied upon by your opposing counsel regarding despite the General Assembly's use of the word may.
Right, and in this honorable court's decision in Ramick, it was held that there's an unreasonable contest unless the employer proves that they had a reasonable contest. So in Ramick, this court substituted the word unless for the word may. And Judge Brobson was following this court's precedent in Ramick when he indicated what he said in the decision in this case.
Thank you.
You're welcome.
Thank you very much.
You're welcome.
Feel free to proceed if you like. Carla Fisher filed a pro se complaint in her individual capacity, but also representing at least at one point her husband and as personal representative of the estate of her son, Corey, alleging that his death was the result of medical malpractice. Defendants filed preliminary objections and in due course a motion to strike the complaint for failure to file proper certificates of merit. The trial court ultimately struck the amended complaint with prejudice. The Superior Court quashed the appeal on the grounds that the trial court lacked jurisdiction over the complaint because it was void ab initio as it pertained to the estate because it was brought by a non-lawyer and constituted a memorandum to the court as opposed to a complaint filed with the court. The Commonwealth Court also held that there was an improper verification or lack of verification, and finally, it held that the complaint should be struck because the certificate of merit rule was not complied with properly. And we granted allowance of appeal to address the propriety of all three of these holdings. And I know that Ms. Krupka and Mr. Fensmaker, you're going to split time. We have a pretty rigorous rule that we don't permit, we have an absolute rule that we don't permit rebuttal, and as a result, we don't permit you to reinforce each other's arguments. Please argue separate points. And with that, Mr. Asprung, please feel free to proceed.
May it please the court. My name is Leon Osprung, and I represent the Bisher family in this appeal. The only Pennsylvania Supreme Court case that was cited in any of the briefs was the case of Schatz v. Farrell, and it was cited for its dicta, where the defense counsel points to the dicta that the court stated that attorneys are needed in this process to assure the public adequate protection in the pursuit of justice. And that is true. Attorneys do assure that attorney representation of clients do assure adequate protection in the pursuit of justice. But there's also a role for the trial judges and the judiciary in this system, because it's the judiciary that ensures civil due process and fundamental fairness. The defense in their papers talk a lot about how inappropriate it would be to reward appellants for the unauthorized practice of law. But that's not really what's going to be rewarded in this case if appellants aren't successful. If appellants aren't successful in this appeal, the people who are being rewarded are the appellees, their clients, and their lawyers, and the trial judge. And they're being rewarded for their lack of legal knowledge and their failures to recognize the issue of jurisdiction and of pro se representation of an estate, and to timely object and move to dismiss this case while the Bishers still had time on their statute of limitations to find a lawyer and file a counsel complaint. Now, as Chief Justice just mentioned, there are 3 issues before the court. 2 of those issues were raised sua sponte on appeal by the Superior Court. The first, and I think most critical issue in this case, is the issue as to whether or not this court has jurisdiction over a pro se complaint on behalf of an estate. It is clear, the law is clear in this Commonwealth, that an estate cannot be represented in a pro se fashion. However, the complaint in this case involved claims both of wrongful death on behalf of beneficiaries as well as survival claims on behalf of an estate. It is clear under Pennsylvania Rule of Civil Procedure 2202 that the wrongful death beneficiaries of a decedent can bring a case on their own as pro se plaintiffs if that estate has not filed suit within 6 months, as was the case here. Therefore, there is no doubt that the trial court had proper jurisdiction over this complaint, over at least the wrongful death claims. And I don't think you can separate out when one complaint is filed with 2 types of claims, Survival Act claims and Wrongful Death Act claims. The court can separate out and say, well, I have jurisdiction over this part of the complaint, but not that part of the complaint. The court cannot do that, Your Honor. The court...
Just so that before you go further, you elaborate on that, a pro se plaintiff files 1 count that is cognizable for, in this case, her, and then can file, and this was a 17-count complaint, if memory serves me, 16 pendant claims which are unauthorized practice of law, and a court's powerless to throw them out because of the 1 good claim?
Well, the court asserts jurisdiction over the pleading, Your Honor. That pleading is the complaint in whole. The court can then say counts A, B, and C are dismissed because of jurisdictional concerns, but the court has jurisdiction over the entire pleading as a whole. Furthermore, once a complaint is raised, defendants are obligated to file preliminary objections. And under PARCP 1028, there are specific categories of things which must be preliminary objected to, or they are waived. They are waived pursuant to Rule 1032. Among those things that are waived, if not raised in preliminary objections, are things such as the jurisdiction of the court, defect in processes, things like verification.
Jurisdiction is never waived, you know that.
Jurisdiction.
Go ahead.
Well, the rule says lack of jurisdiction should be raised in preliminary objections.
But it could be raised here, ironic as it could be, and it would still be cognizable.
Agreed, Your Honor. And we're talking about the jurisdiction of the court over the action.
Is it subject?
Subject matter jurisdiction.
And what makes this a question of subject matter jurisdiction?
I'm sorry, what makes it?
What makes this a question of subject matter jurisdiction? Because someone who is unauthorized to practice law filed a piece of paper.
Well, the Superior Court has set forth in this case that it's a matter of subject matter jurisdiction because there was the unauthorized practice of law, and that an estate cannot be represented before a court without counsel. I believe that is the grounds by which the Superior Court said there was lack of jurisdiction because it would be improper for an estate, as is a corporation, to be represented before a court without counsel. And so because it was not a counseled complaint, and it was brought by on the caption, it was brought by an estate, that therefore the court would lack subject matter jurisdiction.
And I'm just struggling with this notion of shoehorning what's happening here into subject matter jurisdiction. It may be correct, but I've just not been able to quite work that through in my own mind. Is it because there is no complaint? So the court has nothing before it. But is that really jurisdiction? Isn't that more, we don't have anything before us?
I would agree with Your Honor. That seems to be the Superior Court's take on this issue, that because the complaint was not filed by an attorney, the court has nothing before it. Yes.
As opposed to, we don't have subject matter jurisdiction.
It's clear that the court has subject matter jurisdiction over medical malpractice cases. That's correct.
That's why I'm struggling with this notion. And it's not a personal jurisdiction issue because, of course, that could be waived. So it must be a subject matter jurisdiction concept that they're attempting to hang their hat on here.
I would agree. And the argument of the Superior Court, as I read their opinion, was that because the state filed a lawsuit in a pro se fashion, that lawsuit was not before the court.
I think that's right. The minority rule of the country seems to be, if you write me a letter of complaint about a mid-mal, that's not a lawsuit. That's a letter to me. And I think the argument is it's messy because it's filed with the prothonotary and spread on the docket, but this is the equivalent of a letter from a dissatisfied citizen, and that's not sufficient for the court to have jurisdiction. I'm not saying I agree with that, but that seems to be the minority rule. And the majority rule, if I understand this correctly, and correct me if I'm wrong, that's why I'm asking you, is that because it's filed and spread on the docket, it is a complaint, but because it's unauthorized representation, it's voidable rather than void.
Yes, Your Honor, that is my understanding as well.
And that's your point. Isn't that your point? This is not void ab initio.
Correct, Your Honor. It is appellant's position that this would not be void ab initio, that this was a complaint with some cognizable counts, including the wrongful death counts, properly filed through the prothonotary, the fee was accepted, and the case was litigated. Preliminary objections were filed. There was a hearing before a trial judge where face-to-face the trial judge was involved in the case, all before the statute of limitations ran for this client. This case was filed on August 3rd, 2017, and the statute of limitations didn't run until November 12th of that year, 3.5 months later. They were before the court for oral argument the month before. So clearly, the lawyers and the trial judge had an obligation to the court to raise this issue that the estate could not be represented by these two wrongful death beneficiaries pro se. That did not occur. When that was not raised on preliminary objection under 1028-1, that was waived under 1032. And the issue of a verification is a similar issue. To say that a complaint is void ab initio, because...
Before you move on to verification, just one more. It's a very interesting case. And with great respect, because I appreciate your client lost her 25-year-old son, and that's heartbreaking, and I understand that. But to the extent that you prevail that this is a voidable rather than void complaint, again, putting aside for a second the wrongful death which she could bring, which I had not thought of, I don't think I read that in the briefs, but putting that aside, to the extent that this is a voidable complaint, again, and with deep respect for her loss, this was abusive litigation on her part. As I already said, she filed a 17-count complaint against 11 different medical providers, including a resident and a nurse anesthesiologist. She filed motion after motion, and emergency after emergency, and amended pleading after amended pleading. And the truth is, if somebody's burdened here, not that they can't afford it, it's the insurance carriers and the doctors who have spent a fortune dealing with again, what I respectfully view as abusive litigation. Under those circumstances, even though it's a different theory, why shouldn't we just say this voidable complaint should be void and put an end to what's been torturous litigation because of your pro se client?
Well, I'd like to address Your Honor's first point, and that is that this was an abuse of litigation. Not once did the trial court raise such an issue. Not once has
I thought the trial court, who's a wonderful, gifted judge, was extraordinary, kind, and patient with your client.
And who you criticize for lack of legal knowledge, which is a pretty harsh thing to say about a judge.
Well, Your Honor, it's my role to be respectful to the court and to be respectful to the trial judge who spent a lot of time on this case and who attempted to give a pro se client instructions and opportunities to amend and fix and to follow the legal process, which my clients, before I was involved in the case, tried to do to the best of their abilities. And although we haven't gotten to that yet, I think I will show the court that the certificates of merit that were eventually filed at the end were more than adequate, and we'll address that at the end. Perhaps the court will never get to that issue because we'll just find it void ab initio. But
Well, my question, which I don't think you quite answered, putting aside waiver arguments, is assuming that I accept that it's voidable, why wouldn't I just say that your client, notwithstanding her pro se status, has had more than ample opportunity, as you just described, because of the kindness of the trial judge, and this complaint should be voided at this juncture?
because of fundamental fairness, Your Honor, because the client was never told that they could not proceed without a lawyer. And I think that there's an obligation on the part of the trial judge, not just to recommend that a client get a lawyer, and she did have some attempts to get one, but to make sure that the clients are aware, under fundamental fairness and procedural due process, that if they do not have a lawyer, that this case will be dismissed. Now, just the fact that...
Move on to verification if you want. That's a fair answer. I appreciate it.
A couple other points on that. Just the fact that we're arguing that the trial judge should tell the client that she must get a lawyer to proceed, in and of itself means the complaint should not be voided ab initio, that the trial judge has the authority and the jurisdiction over this complaint to give leave to amend a technical procedural defect in the complaint. That is the fact that it is not counseled.
Counsel, before you move on to verification, how is it that the wrongful death action gets quashed? Didn't these plaintiffs aren't they the wrongful death heirs?
They are both the wrongful death heirs of their son, yes.
And as such, individually, they could have brought this action, wrongful death action, pro se.
Correct, Your Honor.
There's no rule, and I always get confused with wrongful death and survival actions. There's no rule that you have to bring both.
There is a rule that if the estate brings the claim, the estate brings both wrongful death and survival acts. If there is no litigation instigated within 6 months of the death, then under Pennsylvania Rule of Civil Procedure 2202B, any wrongful death beneficiary may independently bring a case at that time.
But it's under no obligation to also bring the action on behalf of the estate.
They are not, and in fact, unless, most of the time those wrongful death beneficiaries are bringing that action at that point because they have not been appointed administrator or executor of the state, and they do not have the authority to do so.
And what did the Superior Court quash? Only the action brought by the estate?
The Superior Court has quashed everything, all potential claims. Now, the trial court threw out all claims based on the certificate of merit issue that we haven't talked about yet.
Different issue, but...
Correct. But at the trial court level, they didn't address this issue of the fact that these were wrongful death beneficiaries, and that they just said the whole complaint in its entirety was quashed ab initio because an estate brought both those claims without counsel. The verification issue. This issue was also raised sua sponte by the Superior Court, who found that a complaint must be verified by a party with knowledge as to the facts of the complaint. This complaint, first of all, was signed by Carla Bisher and Brenton Bisher, her husband, was signed, and it's in the reproduced record at page 55A is their signature. And not only was it signed by the clients, it was their signatures were notarized. There is also a rule that talks about when an individual signs the complaint. Pennsylvania Rules Civil Procedure 1023.1C states, quote, "The signature of an attorney or pro se party constitutes a certificate that the signatory has read the pleading, motion, or other paper. By signing, filing, submitting, or later advocating such a document, the attorney or pro se party certifies that, to the best of that person's knowledge, information, and belief, formed after a reasonable inquiry under the circumstances, C3, the factual allegations have evidentiary support," and it goes on. By signing this pleading and having their signatures notarized, under the Pennsylvania Rules of Civil Procedure, these pro se plaintiffs did in fact verify this complaint. So this is simply a procedural, technical defect that there was no verification. If we start saying that complaints are void ab initio when filed, when they do not contain a verification, or when that verification is improper, for instance, I've seen many times in my practice, counsel will sign a verification rather than the client because of the lack of time and the deadlines that the court has, and then later a verification signed by the client will be substituted or amended onto the pleading. When we start saying that a pleading is void ab initio because it doesn't have a proper verification, we're going to open up a whole Pandora's box of litigations, of missed deadlines, missed statutes, etc. A verification is a procedural part of the complaint to ensure to the court and to the opposing party that the averments in the complaint have some justification based on somebody's personal knowledge or evidence that they have in their possession. We have to be sure that we're not going to undermine litigants, undermine complaints and pleadings by saying that when we lack this sort of technical guarantee, one that, by the way, is enforced through the preliminary objection process, which was waived in this case, that we're not going to undermine the whole complaint, and we're not going to say that that complaint is void ab initio. There's simply no law in this Commonwealth, or that I could find, that says a complaint is void ab initio and not before the court because a verification hasn't been signed. In the cases cited by the Superior Court in its decision that the complaint was void ab initio because of this verification, the three cases, Atlantic Credit, Monroe Contract, and Ruppel v. Bluestein, in all three of those cases cited by the Superior Court, when the verification was improper or not present, the case was not dismissed ab initio. In the Atlantic Credit case, the case was sent back to the trial court. In the Monroe Contract case, it was PO'd based on a verification that was signed by counsel, and the court actually specifically said that as a bare minimum, the client should be granted leave to amend the verification. And in the Ruppel versus Bluestein case, again, the verification issue was raised on preliminary objections, and the complaint was not dismissed based on the verification not being there. The complaint was not dismissed, but the preliminary injunction that was sought was denied, which is very different than dismissing the underlying complaint. So there simply is no support in this Commonwealth for dismissing a case back based upon a procedural defect in a verification. That brings me.
You turn your attention to the certificate of merit, which I think is a more significant issue before us than the verification.
Absolutely, Your Honor. The certificate of merit issue. This is a statute that was cited and discussed in the papers by appellees and appellants. The whole question is whether or not the certificates of merit filed the last time by the Bisher family met the statute. Those certificates of merit that were filed at the very end are found in the reproduced record by plaintiffs at pages 454A to 482A. 454A to 482A of plaintiff's reproduced record, appellant's reproduced record. I'm going to talk about one of those 5 certificates of merit. There was a certificate of merit for each defendant individually filed, for Dr. Stelzer, for Dr. Patek, and for the 3 corporate entities. They each have individual certificates of merit. Now, those certificates of merit are similar.
Are those the only parties left in the case at this juncture?
Yes, Your Honor. There was talk in some of the papers about the anesthesia defendants and the critical care defendants. Appellants admit we have not filed certificates of merit as to those other defendants, and they can be dismissed. So there's the 5 defendants that remain. I'm looking now at the certificate of merit for Dr. Stelzer because he's the attending gastroenterologist, kind of the key defendant in this case. It's found at appellant's reproduced record 460A. In this certificate of merit, it's dated, and we have to look not just at the certificate of merit, but also at the form that's filed by the appellant. When you don't have a pro se client, and a counsel simply files a form about the writing that they have. When you do have a pro se client, the litigant must file both the form certificate of merit and attach the writing or the report that they have from the medical expert. So this is the report from the medical expert. It parrots the statute. So what were the criticisms that the court had as to the inadequacy of this certificate of merit? Well, one was that this Dr. Aplt, the expert, was not an adult gastroenterologist. That is simply an error on behalf of the appellees and the trial court. Dr. Aplt is board certified in adult gastroenterology. He's board certified in pediatric gastroenterology.
And when we get into the record, it'll reflect that?
The record reflects that his CV is in the record. Okay. And so that is simply, in my mind, a non-issue. That is simply an error. It was overlooked by the court and by the litigants, but he clearly has the same specialty match as Dr. Stelzer. He is not required to have the same specialty match as the Dr. Patek because she was a resident who was not a specialist. So there's no match required for her. And the other 3 defendants are simply corporate entities. So then when we go to the language, and you go to the last page of that certificate of merit, so it's page, let me make sure I get it right, let me look at the actual record. So page 460A begins with the precipice that was submitted, and then 461A talks about the things in this certificate of merit that were changed from the prior one. It outlines them. And the most important thing that was changed is at the bottom of page 463A. The expert puts into his statement, which is signed by the expert on the next page, 464A. At 463A, the last paragraph, the expert states, quote, "There exists a reasonable probability and degree of medical certainty that the defendants breached the appropriate standard of care and that this breach was a cause in bringing about harm to Corey Bisher." That parrots the exact language of the statute. There can be no doubt that if this certificate of merit doesn't fulfill the requirements of the statute, I've never seen one that does.
Counsel, even though there were separate certificates of merit, could you clarify, did the physician who generated the certificate of merit specify who did what? Did he specify which doctor he was alleging did the acts that he's describing?
There is some talk of all of that within the document. Now, keep in mind.
No, I'm asking, does he specifically tie an action or inaction to a specific defendant?
Yes, in page 463A, Dr. Aplt states, and I'll quote, "Dr. Frederick Stelzer and the Eastern Pennsylvania gastrology and liver specialists did not initiate endoscopy early as they should have when they saw Corey, was significantly anemic with the hemoglobin, goes on. He uses the word that the doctor should have. Those are, even though we don't have magic words in Pennsylvania supposedly, those are magic words that mean it's a requirement. They also specifically mentions in this final certificate of merit, Dr. Patek. He says, his condition worsened when Dr. Bonnie Patek, a certified registered nurse anesthesiologist, intubated him at the bedside, causing a massive aspiration of gastric contents. So there are specific acts tied to the individuals, yes, Your Honor. And the language, and by the way, the language of the certificate of merit rule is a general language within the statute that is parroted in this final set of expert reports. So I think it's pretty clear. I'm not sure what the defect is that appellees feel remains in these certificates of merit that were filed in the final round and then right before the trial court dismissed the case. But it seems clear that it was met. There is one certificate of merit for each defendant, and we have to look at both the form that is filed as well as the writing of the expert. The form that is filed clearly identifies as to which doctor or entity this is entitled, this is directed, and the report does give specifics. And that is true even on the corporate negligence issue. The report of Dr. Ament does even specifically speak to the significant corporate negligence of Lehigh Valley Hospital and the failures that the hospital had. So I really think it's clear when you look at the proper version of the certificate of merit, and it may be that it's confusing, there are multiple versions that were eventually filed with the court. When you look at the right version of the certificate of merit, it clearly meets all the requirements of the MCARE Act and more.
Yeah, Counsel, was there vicarious liability count against the defendant hospitals?
There is. There is. And the other thing that I think is important to note is that there's clear law, and the note to the rule, as I briefed in my reply brief, states that when you have vicarious liability for agents of the hospital or agents of Dr. Stelzer as an attending, that those agents need not be identified by name. So those counts should also be permitted to remain. And so, just to summarize, there are the three issues in this case. I think the certificate of merit issue, although it was the one that got this case dismissed, is the clearest and most obvious that that was an error of law by the trial judge. The question is whether or not this court wants to establish, in this case of first impression, whether or not a complaint on behalf of an estate filed by pro se counsel is a procedural defect that can be amended and corrected, or whether it's void ab initio. Appellants assert that it is simply a procedural defect, that when a case is filed within the statute of limitations, the litigant must be given a period of time to amend, especially when that issue is not raised on preliminary objections by the defendants, but is rather being raised sua sponte by the court. This case should be sent back to the trial court, nunc pro tunc, to resume where it was. Thank you.
May it please the court. I'm Adam Fenstermaker. I represent Dr. Stelzer and his practice, Eastern Pennsylvania Gastroenterology and Liver Specialists. To avoid any duplicative arguments today, I'm going to be taking the first issue with regard to whether the complaint is void ab initio, because the court lacks subject matter jurisdiction, because it was filed by a non-attorney engaged in the unauthorized practice of law. Attorney Krupke is here on behalf of Lehigh Valley Hospital. She's going to be taking the second issue with regard to the verification statements. And then the third issue is very specific to each individual defendant, and with the court's permission, I would like to address that with regard to my client, and Attorney Krupke can address that with regard to her client. Thank you, Your Honor. So as the trial court, or as rather the Superior Court ruled, The courts lacked jurisdiction in this matter because jurisdiction, especially subject matter jurisdiction, is not waivable, and the complaint filed by a non-attorney is void ab initio. And the Superior Court, and actually the trial court as well, during their memorandum opinion, once the appeal was requested, cited several cases, including the Spirit of Avenger Ministry case, the McCain v. Curian case, which holds that a complaint is void. It's a legal nullity. Effectively, as Chief Justice Bisher stated, there's effectively no complaint, there's no pleading in front of the court, because this pleading's a legal nullity.
I think Justice Donahue and I were both struggling with that concept, even though there is case law to support it, that how can there be no subject matter jurisdiction? The issue really is there's no subject matter.
There's no subject.
There's no subject.
It's not a subject matter jurisdiction question.
It's just hard to wrap your head
It's a little
around
bit of
it
a
being
circular- sorry, I
jurisdictional
didn't
when
interrupt, Your Honor.
if it's void ab initio, it's not even before the court at all.
Right, and the court can't have jurisdiction over something that's not before it, I believe is what the Superior Court's reasoning is. Unfortunately, the Superior Court did not really delve into that particularly
You
in
understand
detail.
it's a little bit of a difficult concept.
I do.
That's a good answer.
Thank you, Your Honor.
And it is the minority position around the nation is that it's void ab initio. It's not, wasn't created out of whole cloth by the Superior Court.
No, but the courts of this Commonwealth to date seem to support the minority position that the complaint is void ab initio, that the complaint filed by a non-attorney engaged in the unauthorized practice of law is a legal nullity. And that's, again, there's several cases that stand for that proposition within this Commonwealth, even if other states in our nation have taken a different approach with it.
Although if it's not a subject matter jurisdiction issue, then it is waivable, right? You can't waive an objection to subject matter jurisdiction.
Well, Your Honor, I would argue that it is a subject matter jurisdiction.
No, we've argued about that. I said if it's not, then it's waivable, the objection to which is waivable.
Yes, I would agree with that statement.
Counsel, could you address a couple of the examples that Judge Bowes cited in her defense? Why is a complaint filed by someone who is not authorized to practice law void ab initio, but a notice of appeal is not?
I'm not sure I understand
Why does
Your
a
Honor's
notice of
question.
appeal somehow exist if it's filed by someone who's not authorized to practice law when a complaint would be treated differently? Why would that be?
That's an excellent question, Your Honor. I would argue that because the court is still trying to determine whether or not the complaint is a nullity, whether it is void ab initio, that appeal then becomes an issue, and whether or not the court's pleading is a nullity.
Yeah, but her point was a little different. I mean, the Superior Court has allowed correction of notices of appeal that were defective because of the identity of the person or not person, so to speak, if it was a corporation who files a notice of appeal. And I just don't know, I don't know how you treat those two things differently. I mean, maybe the law is wrong on the notice of appeal. Maybe they're void ab initio also, but you can't have it both ways.
It's an excellent question, Your Honor, and it's not something that I believe I can actually answer for you. It seems to be that it's handled differently on the notice of appeal. I don't know why the notice of appeal is handled differently.
I have a similar question, is what would happen in the event where the estate being represented pro se by non-lawyers were sued by an attorney, filed a complaint? They get an automatic default judgment?
It's an excellent question as well, Your Honor. It's something I had not considered, so give me a moment just to think about that. If a estate were sued, I would imagine that they'd be required to find counsel. Otherwise, they'd be in default. That would be my best guess.
Counsel, just for clarity purposes, so I could keep these two things separately.
Sure.
why were the counts of the complaint that dealt with wrongful death errors dismissed? Those individuals had the right to proceed pro se. Why would that be quashed?
Those, I believe, were dismissed based on the verification statements. Those were separate issues. So there was the issue with regard to the estate's claims, and those were dismissed due to the fact that they were brought by by a non-attorney practicing the unauthorized practice of law. Then there were the individual claims, which were dismissed because they did not have the proper verification. And then ultimately, even had the jurisdictional issues not been raised, the complaint was viewed as invalid due to the defective nature of the certificate of merits.
Why isn't a lack of a verification a waivable objection?
It's a great question. I'm going to have Attorney Krupke handle that one because she's handling the verification issues.
Okay.
May
I'll
I
keep that
ask-
in my mind.
May I ask you, I said to your opposing counsel, even if we find that the complaint is voidable as a question of first impression and not void ab initio, why shouldn't we void it given the appalling history of the litigation? And he said, because my client never had fair notice that you have to go get a lawyer by this date, trial court, or I'm going to dismiss the case. That struck me as a fair answer. Any thoughts on that?
It is a fair answer, Your Honor, if you ignore. Now, I will say I'm the only attorney here who was actually before the trial court on this matter. And having dealt with the trial court and having dealt with the appellants, if it was Ms. Bisher's desire to represent herself, if she had said, I can do better than any attorney here, I want to represent myself, I would argue that maybe it would be fair that the trial court had said, that's not something you're able to do. But she represented to the court on multiple occasions. Not only did I try to seek counsel and was then unable to, I'm continuing to seek counsel, and I'm still not able to get an attorney. In fact, right up to the time of the appeal, when she initially filed her notice of appeal, the Superior Court said, let's take a step back, explain to us whether or not you're an attorney and whether or not you're even permitted to bring these claims. And she replied, and I have her statement here. She replied to the Superior Court, had appellants been able to retain counsel, they never would have filed their case pro se in the first place. And I think
You construe from that she couldn't get a certificate of merit and couldn't get an attorney to stand behind the case?
I'm not construing it from that. I'm construing it from her own words during the course of the trial court proceedings. She said, I have been going to attorney after attorney after attorney. I've gone to expert after expert after expert. I'm doing my best. This was a grieving mother who was trying to get justice for what she believed was malpractice. And the trial court explains throughout their briefs, and the Superior Court, I believe, found it persuasive, that this woman was granted an exceptional amount of leniency to cure any procedural defects so she could get closure with regard to her medical malpractice.
And I understand that, but back to Chief Justice Baer's question, how do you respond to your opposing counsel's argument that she never got notice because the trial judge never said, look, you're facing dismissal if you don't come in here with an attorney?
Because she didn't face dismissal, she didn't come in with an attorney. She was able to continue her claims. She was able to do as best she could to keep her claims going and to file her certificate of merit. Until her certificate of merits were deemed effective and then dismissed. It's, I think, really important for the court to consider the fact that this was a decision of last resort. Carla Bisher, when she brought her complaint to the court, knew that her statute of limitations was on the verge of expiring. She brought her complaint in August, and throughout the course of August, September, October, and November, until the statute ran, was saying, I'm still trying to find counsel. I can't find counsel, so please accept my pleadings. Please allow me my day in court.
Once the trial judge determined that the complaint was void ab initio because it wasn't filed by an attorney, were there additional orders entered by the court after that?
Your Honor, at no point in time did the trial court determine that the complaint was void ab initio. That was brought up by the Superior Court when she filed her notice of appeal.
I'm sorry, I should rephrase that. After the trial court's initial orders in the case, did he continue to rule separately about the verification and the certificate of merit, or was it all in one bundle?
It was all in one bundle because the issue of her unauthorized practice of law did not occur until after the case had been dismissed.
Gotcha.
But really, in fairness, the verification issue was raised to responded by the Superior Court, was it not?
It was, yes, Your Honor.
Go
I
ahead.
have a follow-up, if it's okay. I'm going to ask you a question with regard to an example. If the estate was the defendant, would they get a default? And you said no, because it was an estate. They would bring them in and tell them that, give them notice that they had to get an attorney. And isn't that what the appellant's asking for in this instance?
I think the appellant's asking for, effectively, asking for a longer statute of limitations than what's prescribed by Pennsylvania law. She had 2 years to bring a complaint. She was nearing the end of her time period at which she could bring a complaint. So she engaged in the unauthorized practice of law so that she would not lose her ability to bring a claim. She was up against the deadline. She said, I can't find an attorney. Please accept my complaint. That's effectively what occurred before the trial court level.
I think we understand the voidable argument, not even the verification argument. Again, I don't recall. Are you arguing certificate of merit?
I am arguing the certificate of merit only as it relates to Dr. Stelzer. I believe the certificate of merit, because it seems to be very factual, should be addressed by both counsel, if that's all right with Your Honor.
Why don't you turn to that?
Thank you, Your Honor.
Okay, can I just ask one more question, really, and it's a follow-up to Justice Mundy's question, and I'm going back some time in my mind on this, but if a plaintiff wants to sue an estate, isn't it the plaintiff's responsibility to make certain that an estate is raised?
I'm sorry, could you repeat the question?
Isn't it a plaintiff's responsibility to make certain that an estate is raised if the plaintiff wants to bring a claim against the estate?
I believe so, Your Honor.
And along those lines, I mean, there appears to be some symmetry in that situation that, you know, it's not quite as clear as the Superior Court seemed to think it was about this problem in terms of the pro se representation of an estate in that context also.
I'm sorry, Your Honor.
And I'm still struggling with this notion of, you know, how the Superior Court analyzed this, but.
Are you posing a hypothetical, just so I can understand your question?
Yeah, I am. I mean, it appears to me that when in our jurisprudence, in our procedure, when you're dealing with an estate, there's a certain subset of rules that apply.
Yes.
And I'm not suggesting that an estate can proceed pro se, but when that happens, my question to you is it the opposing party's obligation in some context to make certain that the procedure is appropriately being followed when you're dealing with an estate action?
And I think it depends on which procedure, Your Honor.
This procedure, for example, I mean, and I do not fault the trial court in this context at all. I mean, as Justice Bisher said, I think the trial court did a yeoman job here. But my question to you is, you were abundantly aware during the course of this proceeding, given everything you've just told us about the conversations with the court about the pro se representation of the estate. Why wasn't a motion to strike filed?
Your Honor.
Why not move to strike the complaint at that juncture, the counts as to the estate?
Your Honor, the Superior Court asked me the same question when I was before the Superior Court. And to be completely frank, I have to plead mea culpa on this one. I had no idea that she could not represent herself as the administrator of the estate. That was my mindset. She's the administrator. She's representing herself as administrator. I was unaware of case law saying anything to the contrary.
It is absolutely a novel question.
But we should hold her to the standard of knowing that.
No, I don't think we should hold her to the standard of knowing that. The question is, did her unauthorized practice of law, does that give her the opportunity to remand her case back to the trial court level and start this all over again? It wasn't that she was dismissed because she was engaging in the unauthorized practice of law.
Let me help you so we can move on. Your position is that the complaint was void as a matter of law, there was no discretion at all.
Yes, Your Honor. All right,
Why don't you do certificates of merit?
I'll move on to the certificate of merit. So the certificate of merit, it was struck at the trial court level with regard to Dr. Stelzer and his practice for not one but two reasons. The first reason was that it did not specify which defendants deviated from the standard of care, and then that deviation caused harm to the plaintiff. Now,
Question I asked your opposing counsel, and he seemed to suggest with readings from the certificates that he in fact did that.
the certificate of merit, there were 5 certificates of merit, and with each of the 5 certificate of merits, there was one written statement. So just to give a little procedural explanation of how these things work, when you file a certificate of merit as an attorney, all you need to do is say, I'm verifying that I have an expert witness on board who says that there's a reasonable probability of negligence and that negligence caused harm to my client. But if you're a pro se plaintiff, the legislature has made the determination that there's an added requirement. That added requirement is that you need to produce that written statement. This trial court, for whatever reason, does not take the pro se plaintiff at its word the way it takes the attorney at its word. So Carl Bisher initially, during the course of litigation, said, well, I don't need a certificate of merit. The fact that my son has died is reason enough to show that there was malpractice. Of course, the trial court said, no, this is a professional negligence claim. You're going to need a certificate of merit. So then she filed another pleading in which she said it's unconstitutional to require an added level of scrutiny where I have to produce the actual written statement. Trial court dismissed that and continued to delay proceedings a little longer. All of which during this time, Carl Bisher continued to pursue an attorney to take on her case. Finally, she finds Dr. Ament. Dr. Ament's a pediatric gastroenterologist out in California. Dr. Ament wrote a very long letter. And during the course of the long letter, he explains not only his credentials, but the facts of the case, and that he says this warrants consideration for malpractice. And the trial court looks at the Dr. Ament's letter, sees his qualifications, and I raised with the trial court, I said, Your Honor, although he is board certified in adult gastroenterology, he states very clearly in his letter, when I finished medical school, when I finished my residency, and I wanted to get my board certification, there was only adult gastroenterology boards. There was no pediatric board of gastroenterology. I took the adult gastroenterology boards, and then I effectively founded the field of pediatric gastroenterology. He said, for that time, I did X, Y, and Z. I started a teaching hospital. I've trained all these pediatric gastroenterologists. I've treated thousands and thousands of children with regard to their gastroenterology problems. And I asked the court, I said, Your Honor, it seems to me that although he's board certified, since he became board certified in 1974, he's never actually practiced adult gastroenterology. He's only practiced pediatrics. He's the godfather of pediatric gastroenterology. There's a question that I have whether or not he's qualified in the 40 years to offer standard of care testimony in an ever-evolving field of medicine against an adult gastroenterologist.
Well, wasn't the argument of your opposing counsel to that there really isn't that much of a difference between the medical understanding of gastroenterology in an adult and in a child?
Your Honor, I have no idea. I'm not a gastroenterologist.
No, I'm asking, wasn't that their position?
I believe their position is that it's effectively the same thing, adult gastroenterology and pediatrics, but the court wasn't satisfied with that. The court said, I don't know. I can't tell from what Dr. Ament's written if he's qualified to offer an opinion against an adult gastroenterologist because he's not practiced adult gastroenterology from his writings for the last 40 years or so. So the court ruled that he was not it couldn't tell whether or not he was competent to offer standard care testimony against Dr. Stelzer.
And I'm a little fuzzy, but wouldn't you hold a little hearing on that, give him the opportunity?
Your Honor.
Or even give him the opportunity to submit a deposition to say that, a little gastroenterological tract is the same as a big one, just smaller?
Yes, Your Honor. You could hold a hearing on that, but ultimately I believe it's within the discretion of the trial court as to whether or not a hearing is necessary. And the trial court ruled that they were not satisfied that he was competent to testify as to the standard of care against an adult
Without a
gastroenterologist.
hearing.
Without a hearing.
No hearing, no depo.
The next reason which the trial court struck the certificate of merit, it was, again, twofold, one being the competency issue, and the second issue being, did it include the language necessary? Now, the language is not particularly complicated. It's just, is there a reasonable probability there is a deviation from the standard of care, and did that deviation cause harm? And Ms. Bisher, again, at the first letter from Dr. Ament, I believe there were 3 of them filed at different points in times. The first letter of Dr. Ament said, you know, this warrants consideration for malpractice. Then the second certificate of merit said, oh, there's a grave error committed here. And then the third one says, the defendants breached the appropriate standard of care, and that breach was caused in bringing about harm to Corey Bisher. Now, that seems to appear to contain the appropriate language. However, they only filed one statement with all 5 certificates of merit, and it's unclear which defendants that word defendants is referring to. Is it referring to Dr. Stelzer? Is it referring to Dr. Potek? Is it referring to Lehigh Valley Hospital? And the court said, I can't tell, and the appellants have had multiple attempts at this. They've been afforded all of this leniency. It still isn't satisfactory in the court's eyes, and the court struck it. And I believe the trial court, struck it appropriately, and the Superior Court agreed that the trial court struck it appropriately.
All right. Thank you very much.
Thank you, Your Honors.
Ms. Krupka?
Good morning, Your Honor. I'll address jurisdiction first, and I do believe it will be rather brief. This is an issue that, of course, was brought up sua sponte by the Superior Court. I think in doing so, it was not an issue of simply that there was one lack of a verification. As I'm sure the court's very familiar with, there are many times where some pleadings may be filed, an answer, discovery, etc., that a verification is missing. And we are not asking this court to say each and every time an answer is filed, a motion is filed, or discovery is filed, and it's lacking a verification because perhaps someone in the office forgot to put it on. One of the attorneys didn't put it on, that pleading in and of itself is void. Instead, what I think the Superior Court was doing was looking to the reasoning of Monroe and Ruppel and saying, in totality, this is a case where there were so many errors that the lack of a verification now made the complaint void as to all parties. I think we likely would have had a very different result if the only thing that was lacking was a verification.
How can that be, counsel? I mean, I'm just asking you just to somehow, for me, justify that. What is this, the straw that broke the camel's back, void ab initio? I mean, lack of a verification is a subject for a preliminary objection.
And, Your Honor, I'm trying to be most candid with the court.
Okay.
Because I do look at alt credit at Monroe and at Ruppel, and they do seem, if not to say, at least suggest that at some point in time you may send it back to have that verification added. I think in this case, because there was a complaint, there were preliminary objections to the complaint on other issues. It's a 17-count complaint. Some of the causes of action are not even recognizable causes of action. I think added to that is my understanding of how the Superior Court came to the conclusion that we have a complaint that's not signed by an attorney, and then we don't even have a verification either as to those counts. That is my best understanding.
Were the signatures notarized?
On the complaint, the signatures of Mr. and Mrs. Bisher were notarized. When you get to the appeal, my understanding is I don't believe they were notarized, but the only one who signed the notice of appeal was Ms. Bisher.
Okay, but they didn't quash it because of a defect in the notice of appeal. They quashed it because of a defect in the complaint.
That is correct. It's absolutely correct. The Superior Court quashed it because they said the complaint is void ab initio. I believe as to the estate, because it's the unauthorized practice of law and therefore does not exist. As to Mr. and Mrs. Bisher, they indicated that because I think it was the combination of everything, but the lack of a verification, therefore, made it void. And
I'm asking you, counsel, is lack of a verification an objection that should have been raised on preliminary objection?
it absolutely can
And
be
if it's
raised.
not- And if it's not raised, it's waived, correct?
I'm not certain that it's waived if not raised, but it absolutely is a preliminary objection that is often raised.
And then, if it's sustained, the court gives leave to amend to correct the defect.
Correct, Your Honor. I mean, generally, counsel will quickly send you a verification and substitute it. But yes, the court can remand the case for counsel to file a verification to attach.
Thank you.
With regard to the certificate of merit, I would like to address it precisely to my client, who is Lehigh Valley Hospital, and Dr. Patek, because I think they are very, while I support my co-defendant's analysis, I think they are very, very specific, and you have to look at the precise wording of it. I think when you look at reproduced record 175A, there's only one statement against Dr. Bonnie Patek, and the wording is very important.
Once again, what was her specialty? Was she a resident?
She was a resident, Your Honor. But I think what's important as well is when you look at the paragraph, what she was doing at the time.
Well, before you do that, was she a resident in gastroenterology as opposed to anesthesia?
My understanding is she's currently a gastroenterologist, but at the time, in your residency, you have to rotate through everything.
But she wouldn't,
All right.
So she would have done OB at some point in time.
in terms of certificate of merit and her act talk, she did not have a specialty at the time she was practicing.
Correct, Your Honor. She was practicing in a critical care pulmonology floor, going through, my understanding is she was going through those rotations of residency. Although one thing I would say is we have residents who go through the rotations of residency. At some point in time, they're delivering a baby. Does that mean any doctor can opine against them as an expert in the delivery of a baby? Can a plaintiff get a pathologist to say this resident improperly delivered a baby because the person's only a resident and doesn't have a subspecialty at the time? I mean, at the time of the alleged, and I'm not sure that what they're alleging she did wrong, because I don't think it says here at all, but her care is said to have happened during an intubation with a nurse anesthetist. So I'm led to believe that they're criticizing her care at the time of the intubation, which would be anesthesia, and we have a gastroenterologist who's now opining against a resident for doing a duty that's most closely aligned with anesthesia. We have nothing to indicate that this gastroenterologist in the last 10, 20, 30 years has ever done an intubation. However, I think we also need to look at what has to be shown. It has to show that there's a probability to believe that there was a violation of the standard of care, that Dr. Patek did something wrong. And that's not what the language says. It's about halfway down on the reproduced record 175. This is all that it says about Dr. Patek. Which is Corey, his condition worsened when Dr. Bonnie Patek and a certified registered nurse anesthetist intubated him at the bedside, causing a massive aspiration of gastric contents. Doesn't say when they improperly intubated him. This is the same as saying someone died, therefore you're negligent. What they're saying, if you would accept this as a certificate of merit, is his condition worsened when he was intubated, i.e., automatically, if something bad happens, you did something wrong, Dr. Patek.
I thought that the written statement that was filed as to all of these defendants included the language that is required under the Certificate of Merit rule,
So, Your Honor, I think it has to be,
that there exists a reasonable probability that the care, skill, or knowledge exercised or exhibited in the treatment, practice, or work that is subject of the complaint fell outside of the acceptable standard of care, and such conduct was a cause in bringing about the injury.
I think when a doctor, in this case Dr. Ahmed, issues an entire letter, you have to read it in its totality. And when you read it in its totality, for instance, this could be the letter that was put against Dr. Stowe. It could have been about any of the defendants. So you look to the letter to say, because he doesn't define the word defendants, right? So you look to the letter and you say, who's he talking about? And we know what he says about Dr. Stelzer. But what he says, and we know what he's criticizing about Dr. Patek, because he chose to put it in. Maybe a different answer if they chose not to, but they chose to.
I'm confused, and maybe you can help me with
Sure.
this, because certainly you do this for a living. I understand that if it's a pro se litigant who's bringing a professional negligence case, the pro se litigant must attach the written statement, as opposed to the attorney just making the written statement. But isn't the written statement that the pro se litigant has to file the same statement that an attorney would file, only it needs to be signed by the physician?
I don't believe so, Your Honor, if you look at the rule. And I think there's a good reason for that. So when an attorney files that written statement, and I'll be honest with you, it's pretty much check a box because it's a pre-made statement, the attorney is verifying as a licensed member of the bar that they have obtained an opinion from the doctor or the expert that each of the individuals have violated, or there's probable cause to believe that they violated the standard of care and that it caused the injury. And the attorney is charged with having that statement, but doesn't have to produce it. And I think that's because as officers of the court, we are bound to know what our statements must include. And if at the conclusion of the case, I, on behalf of the hospital, win, I can ask that attorney for their certificate of merit. And if that COM is not adequate, I can sue that attorney for fees. I think there's a big difference as to what the outcome is, and the whole idea is to protect the physicians. And I know there was mention of, the insurance carriers. Well, they're not all insurance carriers. Some of them are hospitals that are self-insured. And you want to make sure that there's a complaint with a basis in fact against that hospital and against that doctor, so they don't expend extraordinary amounts of money defending the case, only to find at the end there was an inadequate COM. In the case of an attorney, of a plaintiff's counsel, they are required to know what needs to be in there. So they, one would think, would have a certificate of merit letter in their file so that they can produce that says Dr. Patek improperly performed an intubation, and that intubation caused harm. That's all it would have to say.
Yeah, but let's get back to what you said. You think the rule requires something different for a party litigant as to an attorney. The rule says if a certificate of merit is not signed by an attorney, the party signing the certificate of merit shall, in addition to the other requirements of this rule, attach to the certificate of merit the written statement from an appropriate licensed professional as required in sections A1 and 2. Section A1 and 2 contains the language that you and I have been discussing.
Right.
So as I read this, it's saying, as opposed to just allowing an attorney to sign that statement, that, I have an opinion, I have a certificate of merit that says this. What the party is required to do is attach a statement that contains that, pardon my language, magic language.
Yes, and it's in subsection 1 of the rule, A1, which says that, that there exists the reasonable probability that the care, skill, or knowledge exercised or exhibited in the treatment, practice, or work that is the subject of the complaint fell outside acceptable professional standards and was the cause.
Correct. So if those words are contained in a statement signed by the plaintiff's expert, that would fulfill the requirements of this rule.
I think if Dr. Ahmed had issued a letter which says, Dr. Bonnie Patek breached the standard of care, or there's a probability that she breached the standard of care in providing care to this patient, and it caused the harm, that would be sufficient. But when you have but you cannot ignore portions of a document and just have what we often refer to as the magic words at the end. And I think that goes back to even expert reports. So when we look at an expert report and an expert says, it's most likely that the plaintiff died from this, that's not good enough. They can't say more likely than not, most likely. They have to say excluding all other causes, right? So they say in the body of their complaint, plaintiff most likely died from this. And in the end, they say, I offer my opinion to a reasonable degree of medical certainty. You have that special language at the bottom, the magic words. What our courts have said is you got to read the whole document. And if it conflicts, it's not sufficient. Those magic words of reasonable degree of medical certainty doesn't fix what's above it. And I think that's the same here. Dr. Ahmed uses the word that the defendants breached the standard of care. Okay, he doesn't say which one. So we go back up. He talks about Dr. Stelzer, he talks about Dr. Patek, and he talks about Lehigh Valley Hospital. He talks about gastro as well, Pennsylvania gastroenterology. But those are the only three he talks about, right? So we look at what he says about Dr. Stelzer, and then we look at what he says about.
We will read the record carefully. I think we understand the argument.
If I can't, go.
You're making two arguments. One, Dr. Ahmed was not qualified to offer an opinion regarding Dr. Patek because at that moment in time she was practicing anesthesiology rather than gastroenterology. And assuming arguendo that you're not successful there, that the certificate of merit is legally insufficient because it did not contain the language the rule requires. Is there anything you want to add to that?
Just with regard to Lehigh Valley Hospital, this certificate of merit specifically talks about policies and procedures. And while there's a corporate negligence claim, if you look through that complaint, no time do I believe does it talk about policies and procedures. That's what this certificate of merit talks about, policies and procedures. The complaint has different allegations. So now we're saying a certificate of merit who says, Lehigh Valley Hospital, you're liable because you didn't have the right policies and procedures in place, keeps you in a lawsuit in which policies and procedures are not what's pled. So I think I don't think it's there, so Lehigh Valley Hospital would get out on the corporate negligence, but if it is there, there's many allegations of this corporate negligence, and there's no COM as to those allegations. Thank you, Your Honor.
May I say something, too? I just wanted to point out all three counsel, and I know my colleagues would agree, have done an outstanding job, and if you want to go on the road as a CLE program, I'm sure it would be approved. But each of your clients was very well served today.
Thank you, Your Honor.
granted allowance of appeal in this matter to consider whether it's appropriate and consistent with established case law for a trial court to provide a res ipsa loquitur jury charge under the facts of a complex medical malpractice case where the plaintiff has otherwise presented evidence of prima facie direct negligence. Mr. Gracie?
Thank you, Your Honor. Mr. Chief Justice, and may it please the Court, my name is Robert Gracie, and with Saxton and Stump, I represent Dr. John Zepp, Anesthesia Associates of York and the York Hospital, the appellants in this matter. As the Chief Justice indicated, this appeal arises out of a complex medical malpractice case in which it was alleged that our client, Dr. Zepp, in inserting a catheter for the placement of a central line, breached the standard of care imposed upon him for such a procedure and caused injury to his patient who suffered damages as a result of his actions. The facts of the case are not in dispute. Dr. Zepp, while attempting to place a catheter into the jugular vein of his patient, placed it into her carotid artery, a known complication called arterial cannulation, and his patient later suffered a stroke. That this complication occurred is unfortunate, but under the decisional law of the Commonwealth, it is not of itself a basis for liability. At the trial, counsel for plaintiffs sought an instruction on res ipsa loquitur, which this court has described as a rule of circumstantial evidence. Rather than seeing the case as a res ipsa case, the trial court saw it as a standard of care case, and he submitted it to the jury with standard instructions on negligence, which would have included, of course, duty, breach of duty, proximate cause, and damages. He also instructed the jury on the use of expert testimony and circumstantial evidence. The experts, I should say, disagreed as to both the standard of care and whether or not Dr. Zepp breached it. The trial court decided that this was not a res ipsa case, because the plaintiffs failed to prove that this was the type of event that does not ordinarily happen in the absence of negligence, the first requirement for a res ipsa instruction under the restatement as adopted by this court. This court has held that to be entitled to a res ipsa instruction, all three restatement requirements must be established. So once the trial court, Judge Wren in this matter, concluded that the first element was missing, it was no longer a res ipsa case, and the trial court allowed it to go to the jury as a standard negligence case, and so instructed the jury.
Mr. Gracie, what element was missing?
The first element, that it did not ordinarily, this was not an incident that would ordinarily occur in the absence of negligence.
And why was the Superior Court incorrect in disagreeing with you there? Why was the Superior Court incorrect in opining that Dr. Peppel more than made that a fact issue for the jury?
I think your question is a couple of different parts, Your Honor, and I'll try to answer them in the different parts. I believe they were incorrect because when you look at the totality of Dr. Peppel's testimony, the plaintiff's expert, and if I misstate it and say Dr. Pepper, excuse me, but you understand why that would happen. As I was rehearsing, I kept saying Dr. Pepper and making myself chuckle. There was a dispute between the majority and the dissent. The majority saying that he unequivocally said that this is the type of event that does not occur in the absence of negligence. The dissent challenged that. But not only did he challenge it and reach a different conclusion, which happens all the time, but the dissent recounted, and I'm not, unless you want me to, I'm not going to recount each and every fact, but the dissent went through each and every fact that had been established by the plaintiff's evidence, including Dr. Peppel's testimony, and said this was not unequivocal. What he actually did, and this relates to the ultimate question in this case, what he did was established all the elements starting with the testimony of Dr. Zepp, who was called by the plaintiff in the plaintiff's case in chief as its first witness. Starting with that testimony and using that testimony, Dr. Peppel described the appropriate standard of care for the placement of a central line. He was an anesthesiologist. He does it himself, regularly does it, still practices. and he said it didn't meet the standard of care, and he explained why he thought it didn't meet the standard of care. Judge Wren concluded that that essentially satisfied all of the elements of regular negligence, if I can call it that, without the need, and because it wasn't specifically directed, and when you comb the record, and I looked at it too, as did Judge Tabeel, he doesn't specifically say that. We're criticized in they say we supported the lie or some such thing, one of the amicus briefs, because we looked at the evidence the same as Judge Tabeel did. Nobody said Judge Tabeel lied in making the determination that it was not an unequivocal statement, and what it was instead was support for all of the elements of negligence. So, and that's the essence of our argument. If all of the elements are there, you don't need to rely on an inference of negligence.
I think, that's a point that I'm struggling to get. You've said you don't need it, and you've said you've referenced unequivocal situations, and I think you seem to be channeling the dissent in Quinby rather than the majority. This court has made clear now 2 or 3 times, I think, Jones, Quinby, et cetera, that you can get to a jury on both. Quinby's view, the view of the Quinby dissenters, 2 justices, that you have to pick your horse and ride it, is not the law here or in any state that I'm familiar with, certainly not in Pennsylvania and other states canvassed in various pleadings here. The issue where you keep saying unequivocal seems to bespeak of you, correct me if I'm wrong, that there must be no room for doubt. And I guess my question, bottom line, is, isn't that what we have juries for? And why wasn't Judge Wren bound on these facts to let the jury make that decision rather than to say you can either get to them on res ipsa or on negligence, you can't get to them on both?
Well, I have to disagree with Your Honor that in this jurisdiction, the law is clear that it's an either-or, or not an either-or, I guess is what you said. And no, I'm not trying to channel the dissent in Quinby. If Your Honor says that's what the dissent stood for, that wasn't the basis of our argument. As a matter of fact, I think we distinguish because the dissent, as I think about it here, the dissent in Quinby, as I recall, said that there was some direct evidence, and we disputed that. We think Quinby was a completely circumstantial case. Nobody saw the plaintiff's decedent in Quinby fall off the table.
Just let me read you one sentence from the Quinby dissent to refresh your recollection. The dissent said, quote, "I would hold the doctrine," and that's the doctrine of res ipsa, "I would hold the doctrine is unavailable, whereas here the plaintiff makes specific allegations of negligence and presents direct evidence in support of each element." That seemed, and that was rejected by the majority, which said you can get to the jury on both, which, I think has been Hornbook law going back to Prosser. But you seem to me to be wanting us to take Pennsylvania in the direction of the Quinby dissent, that you can get to the jury on one, you can't get to the jury on both, and I don't think that's ever been the law in Pennsylvania. So let me let you respond.
Well, no, we're not. As I said, in our reply brief, we distance ourselves from the dissent in Quinby because we don't see it as a circumstantial, we see it as a circumstantial evidence case. The dissent in Quinby did not.
But you're arguing the same thing, excuse me, you're arguing that it cannot be, that the 2 theories cannot go to the jury in the alternative.
But we base that argument on language from this court in Too Good versus Rogel, and from and it was one of the bases upon which we sought allowance of appeal, and from the en banc decision of the Superior Court in McNutt that said, if I can find the exact language, excuse me. The doctrine of res ipsa loquitur is a rule of circumstantial evidence which allows plaintiffs, without direct evidence of the elements of negligence, to present their case to the jury on an inference of negligence. The plurality said that in Rogel. McNutt said this, and that was one of the reasons why Judge Stabile dissented, because he read McNutt as prohibiting what they were doing. If you have all the elements otherwise established, duty, and there's no question there was a duty. Dr. Zepp admitted that while called on cross-examination by the plaintiff. He admitted, I was the guy doing the procedure, so it was his duty. He admitted then all the facts that led up to it. He thought he did a lot of things in the procedure leading up to what ultimately was the arterial cannulation. And then he did the last thing that he's called upon to do under the standard of care as established by Dr. Hudson, his expert. There was a great dispute as to what the standard of care should be. The last thing he did was to call the vascular surgeon to come out and fix this.
That's after the horse is well out of the barn at that point. That's really not. The vascular surgeon piece is really not at all the crux of what we're debating here, right?
Well, it is to this extent, Your Honor, and I didn't mean to interrupt you before. To this extent, it is. It's the last part of the process. It's what they're taught to do. And it's even what Dr. Peppel said they're taught to do, because this is a known complication. They have to know how to address it. And if you turn out, and again, this is a very complex, one of the amici on the other side said, oh, it's like driving a car in the wrong direction. The artery takes the blood in one direction and the vein takes the blood in another direction. And, we all know that you're supposed to drive in the right direction. You're supposed to drive on the right side of the street. Yeah, we do all know that. But not all lay jurors know how to cannulate a vein. And they don't know why. And when they lay not side by side, and their expert said, this made this a more dangerous situation. It put him into this danger zone, was his testimony, because the vein lay right on top of the artery.
Even Dr. Zepp testified that in patients over 60, that's very common.
He didn't find it a problem. I'm just saying it's that kind of a thing. That's one of the things that makes this complex. He said, oh, I've done this before. Not that he's cannulated anybody. He didn't. In 500, this was the first time it happened. But he's had that physical attribute before, and he's dealt with it. It hasn't caused a problem before. And most of the time...
Mr. Gracie, I think you've answered Justice Weck's question, and Justice Todd wanted to follow up on hers. So
Thank you, and I forgot your question, Your Honor. I beg your pardon.
Sorry. Mr. Gracie, I have a hypothetical for you. Usually that's the sole domain of our Chief Justice, but permit me to ask you one. I think we can all agree that if a surgeon leaves a sponge in a patient during a surgery and it later causes, terrible medical problems, that's one of the examples of res ipsa loquitur. That's obviously...
Classic.
Yeah, classic res ipsa loquitur, because, there's nothing necessary to prove. It just, is what it is. But in such a case, if the plaintiff, in addition to expressing that view and presenting that evidence, desires to put on an expert surgeon who will opine that doctors are busy, there's a lot going on in an OR, but even given all of that, it's negligence. What would you say to that proffer? So that both theories could be presented to the jury.
Given the hypothetical you asked, Your Honor, I'm not sure that the testimony that you elicited from the expert would have satisfied the requirements for all of the elements of res ipsa.
Well, I just gave you a thumbnail sketch of his testimony. He really would say so much more.
Well,
Yeah,
again,
Mr. Gracie, let me just follow up with Justice Todd. You're making this too hard. Frankly, I don't know why you're arguing the issue at all. I tend to be with Justice Wecht and Justice Todd, and I think your other issues are much stronger. But notwithstanding, you get in the elevator and it falls. You're in the airplane and the airplane falls down. And you as a plaintiff want to be extraordinarily diligent, so you take vigorous discovery and you come up with a theory as to why the elevator fell or the plane fell. Well, all everybody's saying to you is that you can, if you want to, I don't know that it's good trial tactics, but if you want to, you can put that before the jury as well as res ipsa.
the problem that we see with that, Your Honor, and we tried to explain it in our brief, and I think we did, but as the dissenter suggested in the court below, once you have all of the elements established in the traditional fashion, you might have direct evidence, you might have some circumstantial evidence, as there was here. For instance, if I might just give an example, Dr. Aplt decided that, or claimed that manometry, one of the tests that Dr. Hudson, the defense expert, said was part of the standard of care. He said that it wasn't done in this case. And the reason I know it wasn't done in this case, even though Dr. Zepp said it was done, is because it doesn't appear in the anesthesia notes.
Maybe I can I don't know, help you. Did you put on the record that this is the kind of unfortunate event that can occur in the absence of negligence?
We submit that the testimony didn't establish that. The majority said, and we agree with Your Honor, if where Your Honor's going is, does he have to use those magic words? No, you look, the case law says you look at the totality of the evidence. But there was direct evidence of the opposite of that. Dr. Zepp said this can occur in the absence of negligence, but I couldn't find anywhere in the record where Dr. Aplt said specifically that this is the type of event that ordinarily does not occur in the absence of negligence. Even when the majority said it satisfied that.
What do you want? I'm really confused. What do you want here? What relief do you want from this court?
We would like a rule consistent with Too Good, consistent with the en banc decision in McNutt, that where the plaintiff establishes a prima facie case of negligence, he or she is not entitled to the inference of negligence provided by...
Is that this whole case, or do you want something in the alternative if you don't prevail on that? I thought what you wanted was a jury trial without res ipsa.
That's what we got.
Which is the
That's what you got, but then the Superior Court
dissenter's view.
reversed and sent it back.
Well, he's an appellant, he's trying to get a reversal of the Superior Court.
I'm trying to get a reversal. I'm trying to have you sustain the trial court.
Can I follow up, Mr. Gracie? I think you answered the Chief quite directly a moment ago. You do want us to reverse Quinby, and you want us to go back and undo everything back to Jones at least, which is 40 years ago, and I think would undo, everything from Prosser down that we read in horn books and learned in torts. And you want a holding, I think. I think you just told us that you've got to ride the one horse, that you can't get to a jury on both. It's astounding on a couple levels. Only I'll just mention one, which means that if plaintiff's counsel diligently provides the jury a case for negligence, then the more that he or she does that, the more he or she somehow magically disentitles himself or herself to get to the jury on res ipsa, even if it's a really sound res ipsa case. I don't understand what the basis is for undoing this body of common law in Pennsylvania. I guess I'm just not following where this is coming from.
Well, I would respectfully disagree with Your Honor that this body of common law is that clear, because I think if it was, Judge Wren, obviously a very experienced trial lawyer, would have simply said, no, I'm going to give them both. I'm going to give negligence, I'm going to give expert testimony, I'm going to give circumstantial evidence, and I'm going to give this inference of negligence as well. The Superior Court, when it decided McNutt en banc, wouldn't have used the language that I just read to Your Honor, that in the absence of direct evidence of negligence, because that seemingly flies in the face of what you claim, what you're suggesting is settled law. The problem, and it's not, if I might, we've not said that a plaintiff under the right circumstances with the right set of facts can't pursue alternative theories of liability.
Sponge case, can he?
In
The Sponge case?
can't he, is that, I didn't hear the last part, Your
I'm
Honor.
sorry, can't the plaintiff pursue alternative theories of liability, medical negligence, and res ipsa in the Sponge case?
Please let me answer your question no and explain.
All right.
No, because this court has said, well, let me back up. In Too Good, again, it's a plurality. Too Good said this is not a theory of liability. It's a
rule of evidence.
It's a rule of evidence.
Practice of evidence.
Different, if I might. You could have personal injury cases that have, not medical malpractice necessarily, but that have a strict liability component and a negligence component. They're alternative theories. You're going to get alternative jury instructions, assuming the evidence supports both theories. This is not an alternative theory. That's what Too Good says. The Superior Court has likewise said the same thing in the Hollywood, I forget the exact name of the case, it's cited in our brief, but it says it's not an alternative theory, it's a rule of evidence. So, this is what, if I might, if I can find my note here just a moment, because I want to say it accurately. I jumped over it.
We're in no hurry.
Well, I know that I'm the last case, so I don't want to stand between you and lunch. We believe that if you gave the standard negligence, expert testimony, circumstantial evidence instructions that were given in this case, and then you layer on top of that the res ipsa instruction as was requested by the plaintiff, you would be improperly weighing the scale on the part of the plaintiff. And please, if you would, the instruction is in the reproduced record, the proposed instruction, the requested instruction that was denied. It's in the reproduced record, and it says this in part. In addition to relying on the plaintiff's expert testimony, again, in addition to relying on the plaintiff's expert testimony, if you choose to do so, you may also draw an inference of negligence from the circumstances as I have set them forth above. And above, in the instruction, were the 3 restatement requirements for a res ipsa inference instruction. This instruction would have had the trial court repeatedly telling the jury that it could infer negligence in addition to or in lieu of considering the direct evidence of the plaintiff's expert. So what the jury would have been faced with were instructions about weighing the evidence of both parties, including the expert testimony, and as I said earlier, there was great divergence between, number one, the experts didn't agree on what the standard of care was, and number two, they didn't agree that Dr. Zepp violated it. So they'd be told to weigh that, but then with the inference instruction, they'd be essentially told to ignore all that and choose to rely on the inference of negligence instead. Or they might say, they might simply give heightened credence to the plaintiff's expert's testimony, because if he testified, and for the sake of this discussion, if he testified either clearly or the majority below didn't say it was, they said it was unequivocal, but they said it was the equivalent of saying, but if he testified, as was the case in the Jones case, which Your Honor referred to earlier, it was undisputed. The only expert testimony they had in Jones was an expert who said this type of thing, that is the scapular problems when you're doing a hysterectomy or some other type of gynecological procedure, doesn't happen in the absence of negligence. And nobody challenged that.
Well, then you seem to be saying, to get a res ipsa instruction, you need to have what amounts to a directed verdict. And it seems to me that you're, I guess you're essentially saying you can't get the res ipsa instruction unless no reasonable jury would return a res ipsa plaintiff's verdict. And I guess what I'm looking at as I look at these older cases and any cases coming down to now is you just need to get, if you're the plaintiff, you just need to get over the bar to the jury. And it seems that this case, they certainly had that for res ipsa purposes, which brings me back to, I have to infer, therefore, that you are asking us to say you have to pick a track, and that's why I keep pressing you to tell us, aren't you really trying to undo our two-track approach in Pennsylvania?
With respect to res ipsa and negligence.
I want you to answer it one more time. I think we've been through this, and we'll move on.
I'm not sure if I look at those cases, going back to Jones up through Quinby, I think, that there was a dual track. I understand from the Quinby dissent that those justices, who obviously didn't carry the day, might have opted for that type of rule. But I don't think there are some Superior Court cases that talked about this gray zone where you put in some evidence but not enough. And we might be able to live with that, but when you've otherwise proven each to a prima facie level so that you would get to a jury, and in all of the judges who, Judge Wren denied directed verdicts, he denied motions for new trial, the Superior Court majority and dissent both said there was a prima facie case of evidence here. Once you have that, it unfairly tips the scales for the plaintiff if you put this new or additional instruction on top. And that's how we read those cases, that they couldn't establish, Quinby couldn't establish negligence because they couldn't establish cause.
Mr. Gracie?
Yes, ma'am.
I think we understand your argument, and I had not realized it was going to be such a quandary over, whether this was the law or this was not the law, that you can present a case in the alternative to the jury when you're arguing for res ipsa and negligence. So I'm glad we have this case so that we can clarify it. It sounds like what we need is a Supreme Court opinion on this.
And that's, we're asking for that clarification. If I might sum up,
Please.
Your Honor,
But work hard to actually sum up.
I'll do that. The issue for which this court granted allowance of appeal includes whether the Superior Court's resolution of this res ipsa issue conflicted with this court's plurality in Too Good, which was a complex medical negligence case. And in Too Good, the plurality observed that res ipsa loquitur must be carefully limited. It noted that a physician is not a warrantor of cures. It said that making a mistake is not negligence as a matter of law. And it cited public policy reasons that exist for protecting doctors by limiting res ipsa inferences in medical malpractice cases. And then, when you come forward 2 years ago, a little over 2 years ago, this court decided Mitchell versus Shakura. Mitchell, too, addressed a complex medical case and dealt with the issue of admissibility of evidence of known complications when relevant to the appropriate standard of care and when that standard is breached. And I mention Mitchell because Mitchell, the majority, cited Too Good 4 times. The dissent cited it once. They both recognized that Too Good was a plurality, but nevertheless relied on it substantially. They both cited it for the definition of what medical malpractice is. The Mitchell majority cited Too Good for the proposition that physicians are not infallible, and making a mistake is not negligence as a matter of law. And like Too Good, though they didn't cite Too Good for this particular point, the Mitchell majority observed that a physician is neither a warrantor of a cure nor a guarantor of the result of his treatment. And perhaps most importantly—
Mr. Gracie,
Yes,
I want you to pick your words carefully. I don't mean to be impolite at all. I'm going to give you 1 minute and you're done.
I'll jump to my conclusion then, Your
Thank
Honor.
you.
Thank you. But I thought it important, if I might, to
You've
reference—
You've argued very well, but we understand your argument.
the court should adopt the Too Good view and carefully limit the application of res ipsa in medical negligence cases. And for these reasons, we ask you to reverse the decision of the Superior Court, remand the matter for resolution of all of Mrs. Lageman's remaining claims, including the demonstrative evidence claim that they addressed in dicta, which this court decided was not really part of their order and decided not to grant allowance of appeal.
Thank you very much. Well done.
Thank you, Your Honor.
Counsel, Mr. Melillo?
May it please the court. It is the plaintiff appellant's position that the law has been the same in this Commonwealth for a very long time, that the restatement of torts, second section, which is applicable, was completely satisfied by the evidence and circumstances of this case, that in evaluating that particular subsection of the restatement over many years and in many cases, the courts, our courts, both Superior and Supreme Court, have basically permitted a two-track approach and not felt that it was necessary to modify the statement depending upon the nature of the case in front of it. In other words, if it were a premises liability case, it was analyzed the same way as a medical negligence case. And also that, in counter to some of the things I read, and especially in the amicus brief, that there is nothing inherently unfair about the applicability of the law in that way. I have put a great deal into the brief, and I don't want to just repeat
Counsel,
that.
how is this case, well, I guess I'm in an awkward position. I don't think this is a res ipsa case at all, but not because of the reason argued by Mr. Gracie, but because this is a standard medical malpractice case, and the parties, the record has factual issues that need to be decided. So how is this case different than every other medical malpractice case?
What's different is that nobody has an explanation, and by nobody, I mean neither side, as to what occurred here.
Isn't that I don't mean to interrupt, but isn't that the classic reason we use juries?
It is, but it's also not the classic, it's also the classic reason why we have a res ipsa case here. In the usual malpractice case, and I've been doing these cases for more than 40 years, you have a known complication rate for a procedure. We'll just stick with procedures. Back in the day, if you were having bypass surgery for your heart, they would tell you that you had a 2% chance of dying from the procedure. And that's with due care. It is overall, despite the fact that you followed the standards of care, about 2% of your patients would die. So if somebody died during bypass surgery and you examine the records, what you were looking for was a standard of care followed such that the chance of the complication was minimized. That's the doctor's obligation, not to completely eliminate the risk, but to minimize the risk. This is a case where there is no known statistical risk base for it. This should not happen. There was no expert testimony in this case that it does happen in the negative.
I think I'm off the narrow issue, and I understand that, but I think I may write to this, so I wanted to give you a chance to talk. As I read the record, there's a factual issue as to whether manometry was done. The doctor testified he did it. The competing experts noted, well, it's not in the record that he did it, and therefore there's a factual issue as to whether he's being candid, being truthful when he says he did it. There was a factual issue on, I think, long axis plain view and short axis plain view, and which one allows you to see the tip of the needle. And then finally, there was actual testimony that the doctor can do, the operation can be completely appropriate and the patient can die, apropos of the procedure you just mentioned to your heart. And it seemed to be all three raised jury questions that made res ipsa inappropriate.
Yes,
I'm not sure it's before us, but I still wanted to give you a chance.
Yes, but of course, it does not give the plaintiff her best shot at winning without the res ipsa instruction, and please let me explain why.
Please.
This is a case where there's no known base of statistical evidence that this is something that can happen. And for that reason, there was no expert testimony in this case by the defense that this is something that can happen. It's not like this 2% of the time, good care or bad care is going to happen. So you have a very unusual circumstance. And what happened here is that not only was the wrong blood vessel inserted into by the needle in the catheter, it went down 7 inches down the artery into the heart. And what happens under those circumstances is that you get turbulence at the end of the catheter, and you have the blood pumping out at high velocity, and it's basically creating clots and carrying it right up into the brain. And that's
You
why
seem to be arguing against a res ipsa loquitur case.
Well, the doctor's testimony was, I did everything I always do. I did everything right. I have no idea why this happened. I would do it again the same way. It shouldn't happen.
In the opposing expert's testimony, didn't it cast aspersions on that? Didn't it create a factual issue for a jury to decide between these two experts?
Of course, I'm a little prejudiced on this, but I think the opposing expert, to some extent, helped the plaintiff's case because he really couldn't explain it either. Nobody could explain it. But you ask, well, if you got all that, why do you need anything more in terms of res ipsa? And the reason is this. The doctor is sitting there on the witness stand. He is baffled. He's sympathetic. He's trying to be honest. He's pouring out his heart to the juror. I did everything the way I do it. Here's the way I do it. I want to show you on a mannequin. Here's the way I do it. It's kind of like after you get into a car accident, wanting to drive and show people how carefully you can drive. It's an act of God, basically. I can't explain it, but it wasn't me. And the plaintiff does not have a witness to bolster that credibility. Nobody who actually saw it, who talked to the doctor about what he did, who saw the aftermath, who saw the insertion. Nobody who can testify directly the way the doctor did about what occurred. That's why, in order to level the playing field again, it's important that the plaintiff, if the plaintiff can satisfy the elements of the restatement, gets to also use that information.
Well, and that's the critical argument, not to level the playing field, because, what we want to do is see if the elements are there to go to the jury and if the theories can be presented in the alternative to the jury.
That's right. If the restatement had in mind that that you can't use alternate theories, it probably would have said so. It's quite careful. Or some court somewhere before now would have said so in the Commonwealth, and I don't think any did. There are non-medical malpractice res ipsa cases in which the issue is specifically discussed, and I see no reason why malpractice cases should be free from the considerations that were applied in those cases.
And counsel, it's also not the law that we say in Pennsylvania, if you've got a pretty good med mal negligence case, we're not going to let you get to the jury on res ipsa. In other words, putting on your expert to testify to negligence doesn't somehow legally disentitle you to get to the jury on res ipsa if you meet the prongs, right?
If you meet the requirements.
Exactly right.
We're not trying to sort of rough it out and handicap this thing, right?
Right, that's exactly right. And there's some concern expressed, I think, in the amicus brief that these res ipsa malpractice cases will proliferate out of control if you let the plaintiff do both, but that's simply not true. It's not true in my experience, of which there's no evidence before the court. But I can tell you that because most medical procedures have a known risk component to them, and it's often quantified, you're not dealing with being able to eliminate element one or satisfy element one, that it doesn't necessarily happen in the absence of negligence. And that's the vast majority of the cases. And many types of cases are simply unamenable to race ipsa treatment at all, including diagnosis cases for the most part. Communication among providers cases or miscommunication, which in my experience is a lot of medical malpractice, and others as well. So I don't think there's any danger of a proliferation, especially of unfair cases. I said in my brief, and I'll say it here, I think the restatement is self-correcting in that regard. That is, the more complex a case becomes, the harder and harder it becomes to satisfy element one of the restatement. And it takes care of itself in not allowing unfair results.
Thank you very much. That will conclude our argument session. Thank counsel. Please thank the Capitol Police, as always, for taking such good care of us, and thank PCN that gives the public an opportunity to see what we do for a living. We'll stand in recess.